Well, welcome to Age Friendly, and we have a program for you that I'm sure that you're going to really appreciate learning something about. It's about wills, and then we're going to have a second program about powers of attorney. And Rebecca Johnson is my name. I'm the host of the program, and Megan Stuckey is our guest, and she is a staff, I got to make sure I have this right. So it's a staff lawyer with the Advocacy North for Elders and Seniors, and she's from Sudbury and is from the Community Legal Clinic in Sudbury. And Megan, first, welcome to Thunder Bay. Really happy to have you up here. This is great. And you're going to talk to us for this program about wills, and then we're going to go into it. So people are going to see us all summer on the television, which is good because these are really important subjects. When we start off in talking about wills, what is really a will? I'm just going to prelude that for a minute. When you ask people, do you have a will? Half will say yes and half won't. And they could be my age. They really need to have a will. But what is a will? Let's start there.
At the end of the day, a will is just a legal document where you can express, what do I actually want to happen to my property after I die? It's as simple as that. You pick the person who's in charge of following your instructions, and then you leave the instructions. And that's all it really is it's a piece of paper.
When we talk about that, Megan, is the fact of, like, what kind of property do you need? Do you need actually, like, a house, or what is property that comes under a will?
Well, I hear this all the time from people where they say, I don't need a will because I don't have a house and I don't have a vehicle. So what's the point? I just have a bank account. And I hate hearing that of, I just have a bank account, because to me that's the most important piece of property that you actually own. So when we're talking about making a will, we're leaving instructions for things like your bank account. We're leaving instructions for your pets, your children, your furniture, your clothing. Who's going to be in charge of making sure that your landlord is aware that you have passed on and you don't have to rent anymore? Who's going to sell your house if you have a house? Who's going to get rid of your ATV or the canoe that's in your backyard? Whatever it is that you have, that falls under your property.
So when we talk about property, it's anything that you own, basically.
Essentially.
Okay.
Essentially. So we could be talking about vehicles. We can talk about bank accounts, cash, property you have in Canada, property outside of Canada, but it also includes things like investments. Now, it gets a bit complicated because there is some property that falls outside of your will. So if you had a joint bank account with your spouse, when you pass away, that's going to go directly to your spouse. Your will doesn't deal with that. It works the same with life insurance. The life insurance company doesn't care if you have a will or not. So if you have any property that already has a named beneficiary, think of that as falling outside of your estate basket. We're not going to deal with that. But anything that doesn't already have a beneficiary listed, that goes in your estate and your will deals with it.
What happens, as I said at the start, that some people don't have a will? So what happens if you don't have one?
Well, we have law in Ontario that says that if you pass away without a will, there's a list of people who are going to inherit your estate. Everyone says, well, the government's just going to get my money. And I don't know who started that rumor because the government has put in legislation that says the first person to get your estate is your legally married spouse. So that's if you're living in Thunder Bay or you're living in Sudbury, your spouse gets the first $350,000 of your estate. The only exception to that is if you are Indigenous and you're living on a First Nation, then your common law spouse could also inherit. And this catches people all the time because they think, I'm in a common law relationship for 35 years. Of course they're going to get my estate, but they don't fall under the legislation. So it goes your spouse, then to your children, your parents, your brothers and sisters, and then just any next of kin. We're going to find someone who's related to you by blood, adoption, or marriage to get your estate.
So that would be through, as I say, if you don't have a will, that is an automatic, and that would be done by whom?
Well, this is why a will is so important, because if you don't have a will, there's no one who's appointed to do that job for you and decide where that money is going to go, which means a family member or a close friend needs to fill out a bunch of paperwork, apply to the court, and get appointed to be your executor, and then they have to go find your spouse, your children, whoever it is, and give the money to them.
All right. With that, if you don't have one, is there a lot of money involved? Like if you'd have to hire somebody would have to do that. They'd have to pay them. So that could cost you a fair amount of money.
It could. There are law firms that will step in and assist with that. But again, you're always going to be paying a lawyer to do that role for you.
And even if you even if you're an executor, which we're going to talk about during our program today, is the fact that it still could cost you a fair amount of money. Is it even to actually have a will written up? Could that cost you a lot of money?
Having an actual will made can be very costly. So there are free options that are available to people out there. You can make a will yourself as well, but I always say get some legal advice before you do that, just so you're not walking into any traps. If you're paying a lawyer, the price for that is going up and up each year. I've heard people saying they've paid over $1,000. Others say they've paid a couple hundred. So you have to check with the lawyer beforehand to say, what is your fee? And is it going to be by the hour? Or are you charging me a flat fee to get this done?
And I'm just assuming this, and you can correct me if I'm wrong, that the more you have in property or assets, then the more it could potentially cost you.
Yes, where we're seeing more costs with wills is generally people who have camps. And you have a camp that you want to divide up amongst 3 children who live across different provinces, or you have large investments that you want to get divided up. That's where we're seeing more cost associated with wills.
Right. Well, one of the things that people ask is, when should I actually have a will done? And when I'm talking to people, I'm talking to people my age, so we're talking about older adults, but when should you really start to say, I need a will?
Back when I was in private practice, most people would show up for a will either when they've just gotten married and they've had their first kid, or they're an older adult and they're starting to say, I need to plan.
Right.
But really, any time is when you should get a will. You can't tell anyone, but I used to do all these presentations, and I still didn't have my will in place. I just put it in place a year ago. And it really doesn't matter. You don't need to wait for a certain moment to happen, because at the end of the day, your will is an emergency document. It's there in case you're driving along and something terrible happens to you or to your family, and you've put the plan in place already. So even if you're single, even if you don't have children, or you haven't started collecting houses and assets, you should put a will in place, because then you're naming your executor and you're telling everybody this person is actually in charge of making decisions after I die, and you don't have all that chaos of everyone running around.
And I think the other thing with that is you could, I'm just thinking at 18 years of age, you're declared an adult, that's what they say. And so you could start then, but knowing that you're probably going to change it as you get older, you have children, you get married, and you have more assets. So it's something that can be an ongoing document. And would that be a way to look at it?
Absolutely.
Having it done? Yes.
I made my first will when I was 23 years old, and I was going on a student exchange to Norway. I had no property. I had a Leafs jersey, and I wrote a will that left that to a friend of mine and named an executor. I've obviously made a new will since then, but you can update your will and change it as your life changes.
Right, which is a very good way of doing it, so that you're always on top of whatever it happens to be.
Exactly.
All right. One of the things that we're doing this, and you talk about going to a lawyer, and you make a decision of who that would be beforehand, not just walk in kind of a thing. Yeah.
Yeah, always do your research before you just walk in, because there are lawyers who do wills as their bread and butter. That's what they do every day, and they know what they're doing. And there's other lawyers who, they probably know what they're doing too, but they're doing other areas of law as well. So people sometimes want to go to their family lawyer, and other times you want to go to a lawyer who does estate litigation. You find the person you're comfortable with,
and go from
just like a doctor. Right? You wouldn't want to go to someone you don't trust and tell them all of your health issues. With a lawyer, you're telling them about all of your finances, what's going on. So find someone you're comfortable with, and that you're comfortable with the fee as well.
Okay. Megan Stuckey, my guest, and we'll be as we come back to Age Friendly. Well, welcome back to Age Friendly, and we're talking to Megan Stuckey, and we're talking about wills today. And if you don't have one, it's time to stop and listen to what we're talking to you about. And Megan, we talked a little bit about some of the things that you should put in and include in a will, but let's get into a little bit more specific. What do you really include in your will?
If we want to break it down into the simplest form, put your name at the top of the will and say, this is a will. You want to show that you know what you're actually making. So this is the last will of me, Megan Stuckey of Sudbury, Ontario. You put the town that you live in to just help place you. There might be a Megan Stuckey that lives in Thunder Bay as well, so I want to identify myself. The second thing to go in your will is a revocation. That's where you're going to say any previous will I've ever made, that's now gone. We only want to focus on the current will. Beyond that, there's really two things. You want to pick your executor. That's the person who is in charge of following your instructions. They have the authority to make decisions for you. I also recommend having a substitute executor. No one wants to be 99 in a hospital and realizing, oh, the person I named as my executor just passed away before me, and now I have to make a new will here really quickly.
Right.
If you have a substitute lined up, then you don't have to make a new will every time someone gets sick or passes away. Once you've named your executor, the other main thing people put in their will is a breakdown of where is everything going. We call that the residue of my estate. So you say that if everything I own, after I've paid my debts, paid all of my funeral expenses, I've got a nice chunk of change, how do I want to divide that up between my family? Do I want to give everything to one person, or do I want to divide it equally between a bunch of people? And that's really why we're making a will. We're saying, I want to give my money to these people. If you can hit those main points in your will, you've got what you need. Beyond that, everything else is just extra. It's good to have all of that extra, but you want to hit those 4 points.
Very, very important. So your name and your location, et cetera. Well, that's very good information. Can you do that by yourself, or do you have to go to a lawyer?
You do not have to go to a lawyer. In fact, your will doesn't even have to be witnessed by a lawyer. Everyone thinks that I have to go, I have to get it notarized, but that's actually not a legal requirement. In its simplest form, we have something called a holograph will.
Yes.
Which is you take a piece of paper in front of you, you write it all out yourself with your own hand, and then you sign and date it. And that is a valid will. However, it's always better to have witnesses. In Ontario, a valid will needs to have 2 witnesses who is not your spouse, not your children, and not your beneficiaries that you've picked, because otherwise they're not going to get anything from you. So you pick 2 people, and when you sign your will, they sign at the same time. And that makes it a valid will.
When we mentioned executor and somebody to deal with your estate, what does that really mean?
I like to think of the executor as the CEO of your estate, because at the end of the day, they're calling the shots, they're in charge, but they're responsible to the beneficiaries. So their job is to know where your will is, handle your funeral arrangements. They're going to find out where you're living, lock up the house, lock up the apartment, tell your landlord. They're going to notify your bank. They're going to notify the government. They're going to notify your income, your pension plan. Anyone who's basically sending you money or receiving money from you, they need to make sure everyone knows what's going on, because they have to stop bill payments going out, and they have to stop income from coming in. They can also apply for the CPP death benefit or other forms of benefits that they can get. And then they take everything you own and they either sell things like your house or your cars because they want to turn it into cash, or they gift things. Maybe you've got fishing gear you wanted to give away. And once they've got their pile, they find the beneficiaries and they say, this is your share, your share, your share. And they divide it up. They let the CRA know that they've taken care of everything, and then they can walk away.
That sounds like a lot of work.
It's a lot of work, a lot of responsibility for one person.
It is.
You pick someone that's responsible and that you trust, and someone who's good with money. And in fact, there's a rule that if you have declared bankruptcy in the last 10 years, you can't be an executor. You also should pick someone who knows what you own and is fairly close to you. They don't have to live here in Thunder Bay, but hopefully someone in Canada, right, who can step in and handle these things, and they're not across the ocean.
And you need to advise them that they're going to be the executor. Sometimes I have heard this, that a person became an executor, had no idea that they were even in somebody's will to do that.
Absolutely. People do that all the time. And I warn them against that, because your executor does not have to do this job.
No.
They could get handed the will the day after you die and just say, I'm not doing this. I'm going to go on vacation instead and have nothing to do with this. And they have that right. You can't force someone to do this role. So it should be someone who knows about it, knows where your will is, and is willing to act.
Right. Now, what if you have a pet? Like you have it doesn't matter what kind of a pet, dog, cat, whatever. Is that included in the will?
You can, yes.
Okay.
Pets are actually property.
Oh,
I know
all right, yeah.
We consider them family, but unfortunately they are property. So you can gift your pet in your will, and you can use language that says, you know, I've got my dog Fluffy. My dog Fluffy is going to my sister, and because I love my dog and I love my sister, I'm going to give her a gift of $500 for taking my dog, because that's going to be expensive.
Right.
In other cases, you could say to your executor, please just make sure my dog ends up with a family member or someone who's going to love my dog, right? You're in charge. And your executor would be in charge of making sure your dog is taken care of and that gets transferred to the person who's going to take care of them.
One of the things you talked about is the fact that you've got to contact the apartment. Say if you're in an apartment, that's easy. You can go to the landlord and say, I'm whatever. But if you've got all these government programs and things that have to be done, who even knows what that list is?
Well, there's many lists online, which I know everything's online these days, but the Ontario government has actual pages that say, you're acting as executor, what do you need to do? Generally speaking, a lot of it is also still very intuitive, right? If you're over the age of 65, most people are getting some form of old age security, maybe the GIS, maybe CPP. So I need to contact Service Canada, I need to contact Service Ontario, and I need to contact the CRA because I've got to do the last years of taxes.
Yes.
If you can cover the big ones, usually that's going to give you an idea of are there any smaller agencies I need to contact after that.
Can I pick up on the fact that you said you have to do last taxes for them?
Yes, you do. The last year's taxes, you have to make sure that those get filed. And in fact, you shouldn't actually be giving out the estate until you have contacted the CRA and started doing those taxes.
Really? And that is that, give me a reason why that has to be.
One of the first things that goes in the will is a statement to your executor of, you need to pay all my debts, taxes, and funeral expenses.
Oh, all right.
So if there are debts or taxes that are owing on this estate, and instead you take that money and you give it to the beneficiaries, you're going to be in trouble as an executor, and the CRA is going to say, well, you owe us that money because you gave it to someone else and it was supposed to go to us. So you want to do your due diligence.
Right, and that's really, really important. Being an executor, it could take you a year to, I'm just thinking if somebody passed away and I'm just doing it in May, it could take you to the next year to get through the taxes and everything else. So this isn't something that's going to happen overnight.
Oh, no, it does not happen overnight.
No.
And it's not like you're working a 40-hour week every week on this, but there are things that happen in order. They take time.
Yeah.
Sometimes you're waiting for letters to come in. Sometimes you're waiting for acknowledgments. If you have a house and you're selling it for somebody, maybe they passed away in the middle of January. No one wants to buy a house in January.
No.
So you might end up holding on to that house until August when it looks bright and the tree is in full bloom, and then you sell it and you get more money. And usually executors have that discretion to hold on to property and sell it when it's best.
That is good information, to be honest with you. Megan Stuckey is my guest, and we're going to be talking where you keep your will and can a will be challenged in our next segment. So certainly stay tuned. This is great information, Megan. It's very informative, and it certainly will help many people that are out there thinking about whether they should have a will or not and all the rest of it. So thank you. Stay tuned. We'll be back in a moment. Well, welcome back to Age Friendly. Megan Stuckey is my guest, and we're talking about wills today. And one of the things is, where do you keep your will? So where do you keep your will?
When I do my presentations, I always joke, hide it under your mattress. I do not recommend you put your will on your refrigerator, on your mattress. If you're going to keep it at home, put it in a safe location, usually with your other legal documents. Where do you keep your mortgage documents? Where do you keep title of your house? Where do you keep all of your bills? Put it there. Online, they recommend you should have a fire-safe, flood-safe box, and that's great, but we can't always afford that.
No.
So put it somewhere that's out of sight, but it's accessible, because when you pass away, you don't want your family having to search through your entire house, turn over all the mattresses just to find it. Now, if your will is made by a lawyer, some lawyers actually will retain your original will in their offices. So if you've gone to a lawyer, double check. Do I have a copy at home or do I have the original? Because that's very important, because only the original will be relied upon. And lawyers pass away, lawyers retire, and when they do that, their will is supposed to transfer to another lawyer. So you may end up in a situation where you're looking for that law firm you went to 30 years ago and they don't exist anymore. And now you're trying to find which lawyer actually has my will.
And Megan, it's really important. I'll just share this quickly. Is my brother passed away about 3 years ago, and that was the first we got together at his home and said the first thing we asked is, where is his will? because we know we have to have that to do whatever needs to be done. He was a bachelor, and that was the first thing we asked was, where's the will? We were able to find it very quickly, but it's so important to know where it is, and that somebody also knows it in their family. And if you're by yourself, well, then you should also identify that to somebody, even if it's a friend.
Yeah, I always say tell your executor where it is, right? You're trusting them to be your executor. Let them know where to find the will, and you can give them a copy. But I believe strongly that you should always retain the original yourself and then just tell someone where to find it. You don't want to lose track of your own document.
Sometimes families don't get along after somebody dies. Sad, but it's true.
Yes.
So if a will is challenged, how does that work? Like somebody says, I don't like what's in it, or how the estate is being distributed.
So at the end of the day, anyone can sit and grumble and say, I don't like this will, or I should have been given something in this will and I wasn't. It's a surprise. But if they actually want to challenge it, it's not enough to just go up to the executor and say, I'm unhappy, I disagree. They have to bring a court application in order to disagree with the will. That means they have to go through the Superior Court of Justice, and they have to provide a reason why they don't agree with the will. People are only going to do that if they're actually going to receive something, if they were maybe otherwise entitled, or if there was a previous will that said they were entitled to a gift. Because otherwise, why fight a will if you're not going to receive anything?
Right.
Some of the most common grounds to fight a will would be there was an actual mistake on the will. Maybe it wasn't signed correctly. Maybe there's a page missing. Maybe the actual language is so confusing, it's not clear who a gift is going to. Other reasons would be undue influence. If you have evidence that someone was pressured into making a will and they weren't really given a choice about what to do, or if they lacked capacity to make a will, right? Maybe someone's memory is just so bad that there was no way that they would have understood what they're signing or able to remember, getting through that document. And that doesn't mean they made a will and 2 weeks later they forgot about it.
Right.
It means in the moment they were making it, they didn't have the capacity to understand what they were signing.
Okay, yes.
And so you can challenge a will on those grounds, but you have to prove it yourself. You can't just go to the court and say, you proved to me you were capable. That person's already passed away. So you have to be the one to bring evidence and say, there were doctors in there every day, they were unconscious, right? They had a capacity assessment a week earlier. Show something that this person was not capable.
Right. One thing before we finish is, because we're going to get a little bit of time here, is probate. People talk about probate and wills. What does that mean?
So probate is the process by which the courts authorize or acknowledge that the will is valid and that the executor who is named actually has authority to act. Because like I said, you can take a piece of paper and write a will and sign it, name your executor, and that's a valid will. Or you can go to a lawyer and have your 2 witnesses, and that's a valid will. But maybe the bank doesn't want to rely on that. Or maybe the real estate lawyer who now has to sell your camp doesn't want to rely on that. They just want that assurance that they are allowed to rely on this will, and they're not going to get in trouble. So they will often say, go to probate. And when you've come back with your certificate saying this is a valid will, then we will rely on it and listen to what you're telling us.
Is that something that happens a lot?
It basically, if you own property, and when I say property, I mean real estate, it's almost guaranteed. Your estate is going to go through a probate process. If you have large sums of money in your checking account, you're going to go through probate. But at the end of the day, it's not legislation that is saying if you have $5,001, you're going through probate. It's the banks. It's the bank policies that they've put in place. It's the real estate people who are dealing with your property. It's third parties who are saying, this is past what we're comfortable with or what our policy is okay with, so now we want probate.
I'm an exec. I'm just using this as an example. I'm an executor, so I go to the bank to do whatever needs to be done for that person that I'm the executor for that's just passed away. And the bank says you have to go through probate. How do I do that?
Yes.
What do I do?
Well, there's 2 different processes, and we're not going to go into all of them deeply, but essentially if you have a small estate, which is under $150,000, it's a couple forms. You get them online, you can go into the court office sometimes and they'll give them to you. And you're gonna say, here's the will, here's the date the person died, their birthday, they have a bank account, they have a car, they have a little bit of cash, and you record all of that. And then you have to serve it on the beneficiaries. So they have a chance to know, oh, you're going through probate, you're applying, we're okay with that. We have an opportunity to fight if we want to.
Right.
And then after the court has received your application, they will approve it or ask for more information, and then they give you a certificate that says you can ask or act.
Right.
The reason people try to avoid probate is because there is an estate administration tax. We call it maybe a probate tax.
Oh, okay.
And so if your estate is over $50,000, you have to pay a tax when you go through probate. Versus if there's no probate, you're not getting taxed on that.
The government tries to get all of the dollars they can from us. I'm sorry, I shouldn't have made that comment, but it's true at the same point in time. But generally speaking, there is probate that you have to follow those procedures, whatever. Yeah.
Yes.
Okay. And it's what. Is there a last minute we got about 10 or 15 seconds. What would you say to somebody at this point in time about making a will?
I would say don't let your fears about retaining a lawyer or the cost of a lawyer be the barrier that prevents you from making a will. There are free resources. Stepstojustice.ca has a free will designed by lawyers that you can access. Find something and put it in place. And then if you want to go to a lawyer afterwards, do that. But sometimes it's better to put something in place now and not create that barrier or worry about the cost right away.
Megan, thank you very much. This has been excellent. Great information. Stay tuned, and Linda DePiro will be up with our 1 moment of senior exercise.
Hi, I'm Linda DePiro. Elbow tendonitis, also known as tennis elbow, golfer's elbow, but basically it's all the same. It's basically repetitive movement, and overuse causes inflammation at the joint and affects the nerves. So I'm going to show you a little exercise that you can do to be proactive with this. When you flex your hands forward and tuck under, you'll feel energy through the forearm, and that's the area that we want to work. So have your arms down. You're going to do this, but you're going to flip the hands upward. And then keep your arms close to your body so you can rotate. The baby fingers come forward. Fingers stay long. So take it forward and hold it there for 5 seconds. And then release it. And then do it again. Hold and breathe. Holding it for anywhere 5 to 7 seconds. From there, try waving your hands side to side. And then from there, keep your arms still, but have your hands just kind of wave back and forth. We can do the fingers, right? And this is called wind the watch, fingertips together, elbows stay stable, pointed out to the side as the hands go. And you can go a little faster, 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 like you're winding the watch. And then the stretch. I'm going to only show you on one hand. It's a push and a pull and a hold for about 5 to 7 seconds. Fingers under, push and pull. Hold for 5 to 7 seconds. Right hand, fingers to the side. And then the fist really gives you more activation in here, down, and lift. Carpal tunnel, people. Add the little praying hands and push into there and then reverse it. So a very good prevention for elbow tendonitis. See you next time.